Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Please be seated. We'll hear argument in three cases this morning. First is 2328 in the guardianship of James E. Fairley from Bexar County and the 4th Court of Appeals District. Then 2505 in re Eagle Ridge Operating, a petition for writ of mandamus from Dallas County and the 5th Court of Appeals District. Justice Lehrman is not participating in the decision in that case. And finally, 21312, Dylan Gage versus certain underwriters at Lloyd's, a certified question from the United States Court of Appeals for the 5th Circuit. We've allotted 20 minutes for each side in each of the cases, and we'll take a brief recess between the arguments, finishing them before lunch. The arguments are being webcast live this morning and will be in the court's archives later today. We'll hear argument in 2328.
May it please the court, Mr. Enoch will present argument for the petitioners. Petitioner has reserved 5 minutes for rebuttal.
May it please the court, it's good to be back in the courtroom. I had to dust off my jacket this morning to get ready for this. Juliet Fairley is my client. Juliet is in the courtroom. She writes articles for a number of publications, some of them well known. Some of the articles she has written and investigated is on elder abuse and guardianship abuses. My co-counsel is Sue Daniel, who is here. She and I both have something in common. The rarity of we both in contested recusal hearings actually successfully recused probate judges in their cases. This case does, as a background, involve some issues of guardianship and issues of elder abuse. In fact, this court has demonstrated its concern over the years with that. Even in today's Bar Journal, you have amended some rules and proposed them for amendment that change training and qualifications for guardianships. When you talk about families that are fighting over the proper medical care for their elderly relative, you get into some very serious fights. I mentioned that to say that's sort of a background here, but those issues are not before the court. They're for another day and another time. The issue before this court is whether the probate court in Bexar County ever had jurisdiction over James E. Fairley in this case. This case is about jurisdiction. This court, when it comes to protecting property interests, primarily through the default judgment jurisprudence of this court, it has applied a very strict standard on the rules for serving citation and process on the target party. It has required strict compliance in the identity of the person. It has required strict compliance in the address for service. It has required strict compliance on those who serve the process, and it has employed strict compliance on the return of service to the court. All these things require to be demonstrated on the face of the record in the court. I submit that this court is being asked today to decide whether those same principles of strict compliance apply when a liberty interest is at stake, when a guardianship of an individual is at stake. We think the probate court did not have jurisdiction from the get-go in this case, and we think that their orders, that probate court and its orders from that date forward should have been vacated, and we think the Court of Appeals erred. The material circumstances of this case are that the underlying case was only the guardianship of the person, James Fairley. There was never a guardianship of the estate. It was only of the person. The other issue is that there were true services of process here. There was a service of process that initiated the temporary guardianship. James Fairley was in New York. He was served in New York by a private process server, and there was a second service of process. After James Fairley, by a writ of habeas corpus, was removed and brought back to Texas, he was served with process by a private process server when he was in Texas.
Mr. Enoch, given the reality that in the 80s, as you are aware, this whole process of private process server gained a lot of attention. There was a lot of need for it because it was, the thought was that it was more effective in actually properly serving people with notice. And given the issues here where you have a ward in a guardianship who perhaps arguably would be entitled to more protections, for example, having a guardian appointed who would be served or something to make sure that that person has actual knowledge of what's going on, isn't it, the argument is that this was a more effective means of getting this person who had challenges actually served with notice of what was going on. So what is your response to that?
Well, Your Honor, I've got two responses with that. First of all, I think when the statute dictates what the service will be, whether it sort of complies or the court views there's more effective service or somebody argues, I don't think trumps what the statute requires.
But it says other officer.
Well, Your Honor, that's another point I wanted to make. There was a lot of discussion in the briefs about other officer. I think this court can decide this case without even addressing if a private process server is another officer for the reasons that are also listed in the brief. But I do think when it comes to the strict compliance, this court's going to be called upon to decide whether the service was in strict compliance with the statutes and even with the alternate process server that's there.
In talking about strict compliance, although we do require it in the default judgment context, defects in service of process can be waived. And here, a guardian ad litem appointed to represent the ward didn't challenge process in the case, but appeared on behalf of the ward. And in those cases, we don't go behind the service of process to set aside a judgment. And even if we did, we would send it back to the court and allow the court to exercise jurisdiction as opposed to finding the entire proceeding void. So what do you say about the numerous cases that say waiver of defects in service can be had?
There are numerous cases where you have a minor child that certain rights cannot be waived even by the guardian. You have this one where they're claiming this person is incompetent to make decisions for themselves. This would be a case where there are certain rights that cannot be waived and should not be waived by somebody else who appears and says, well, I've got their best interests at heart. I call this attention to the court's attention to the specific statute here. And the one reason I go back, I don't think you can waive. I don't think an ad litem can show up and waive. As a matter of fact, some of the abusive cases with ad litems experienced in this state have been with the ad litems get way too cozy with the judge. They get way too cozy because this becomes their practice to do things. And this court has expressed concern about ad litems. And I do believe the guardianship training, the qualifications for a guardian, the qualifications for private process are all with the court's intention to get at, to make sure that the procedural rights of the party who's going to lose their liberty is protected.
But what procedural right was lost here when you can see that he received actual notice of the proceedings and appeared at one of them in New York, it looks like. And so they continued to advance his rights throughout the proceedings. So versus a private process server versus a sheriff, what procedural right was lost?
Well, Your Honor, under subsection 1.051 of the Estates Code, it says if the person who is the subject of an application for guardianship is to be served in the state, it's to be the sheriff and the constable, which goes one to the question of could it be another officer. If in the state, it's the sheriff or constable. If it's out of state, then it's a private process server. It could be a private process server. If they are disinterested in the case, and they are competent to file an oath. In neither case were those conditions satisfied. And when I talk about procedures, default judgment is always a procedure. But the court has said that is fundamental to due process. And I'm not sure in the default cases, it was a circumstance where they didn't have actual notice. Waiver plays a role in whether they had actual notice and they came into the case, and therefore whether they got served no longer is a question. But in the circumstance of even a default judgment, even if I got actual notice, but if I didn't waive it, I'm entitled to be properly served before the court attends jurisdiction. And in the case of trying to deprive somebody of their liberty interest, I believe a much stronger interest exists for the proper service to be had. And again, it goes to the other officer is an issue that we think goes away for several reasons, not the least of which on the permanent guardianship served in Texas, it expressly says the sheriff or constable. That didn't happen. In the New York case...
Well, what do you think is the best textual evidence, if you think there is any, that supports reading these requirements as jurisdictional?
Well, that's, even in the default judgment context, that's what initiates the lawsuit. That's what entitles the court to draw a party into the court to assert jurisdiction over that party. Now, you can say, well, you didn't have jurisdiction because I wasn't in the state. You can't just simply serve me, but that was never a question whether the service was proper. What initiates the trial court's jurisdiction is the serving of the party who's to be hauled into court to answer for whatever conduct the plaintiff asks. If they're never served in the case, there's no authority of the court to render default judgment, no authority of the court to order them to do anything.
My question is really whether you think there is some provision in either the ones that we're talking about, 1051-103 or 1051-051, or some other provision in the Estates Code that indicates the legislature's intent that these be jurisdictional.
I guess I don't have an answer for the court on whether it was intended to be jurisdictional. It simply said if you're going to deprive some of their liberty through a guardianship action, this is how you have to do it. Now, if you don't do it, I don't know what the other answer is other than the case, if it comes up here, if the court never had jurisdiction, the orders have to be vacated.
So it would be the background principle that service is always jurisdictional.
The initial service of citation, the threshold question of starting a lawsuit would be a question of jurisdiction. I have not attached jurisdiction if I have not served the party to be targeted.
And are we, to be specific, we're talking about jurisdiction over the person, not subject matter jurisdiction?
That's correct. How do I get this person into court? And the rules are very clear. And
If Fairley had been competent, could his appearance in court have waived service?
if Fairley had been competent, I think his appearance in court could have waived the service.
And how do we know whether he was or not?
We don't. He didn't. They filed some pleadings up in New York where he didn't appear. And all the litigation was that he was not competent.
But if he actually was, then service is not an issue.
That'd be correct, but that determination of competence has not been, and everybody's been fighting over it, and now he's dead. I would submit that the service on out-of-state, if you look at Appendix 2 in the clerk's record, you will see that Sarah Clark says that she's over 18. That might be sufficient in New York to be presumptive that they're competent to make an oath. That's not in Texas. And she says that she is not a party to the litigation. She has to be disinterested, not a party to the litigation. She does not say she's disinterested. She says she's not a party. That's a little bit too precise, particularly if you note that the notary that took down the application was actually the lawyer representing the other side in this case that they gave you the pleadings on this morning. We don't think they're either disinterested or competent to make the oath, so we think it fails. Another point for why it fails, you'll find it in the record, it is required to be returned either endorsed on or attached to the citation. That's subdivision 151 of 1051. And this page is the only return that was given by the one who served in New York. It was neither endorsed on nor attached to the citation. None of that was returned to the clerk's office. The other citation, of course.
Petitioner filed claims that were then merged or transferred over to the probate, that the probate court transferred over to itself. And then respondent filed a Rule 91A motion to dismiss those claims, and then the petitioner filed a TCPA motion to dismiss the Rule 91A motion to dismiss. Do I have that right in the procedure?
Well, there were several things going on. The Court of Appeals addressed one of those issues. They didn't address all the issues. But Ms. Fairley has objected throughout to the probate court accepting jurisdiction of her independent claims, wrongful death, and her claims on the family trust. Understand that she filed after Mr. Fairley died, she filed a wrongful death case and asked for an accounting of a family trust, none of which were part of the probate proceedings. And as the College of Probate Judges tell you, the statute, once the individual passes away, there is no guardianship left of the person. And all of this transaction about transferring that case was after Mr. Fairley died. And as a result, the probate court would have no jurisdiction even to transfer the case.
Am I correct that it was a Rule 91A motion to dismiss those claims followed by a TCPA motion to dismiss the Rule 91A motion?
I believe you're correct.
Not a plea to the jurisdiction, and the trial court denied the TCPA motion to dismiss, but never ruled on the Rule 91A motion to dismiss?
The probate court dismissed the entire case.
Okay, so denied yours and granted 91A.
91A. But if the court had no jurisdiction to begin with, we believe we are still valid. And certainly it's not moot based on the probate court's attempt to dispose of a district court case.
Just in that line briefly, why can't your client just file a new suit in district court on this? Wrongful death.
I suppose she could, but of course, I think you'll have someone, I would guarantee you, they claim that these were issues that were already disposed of by the trial court in all of the motions and pleadings when the trial court dismissed the case. And the Court of Appeals has dismissed the case, made it final.
Any other questions? Thank you, Mr. Enoch. We'll hear from the respondent.
May it please the court, Ms. Cavaretta will present arguments for the respondent.
Good morning. I'm Laura Cavaretta. I am here actually acting pro bono on behalf of Morissette. We call her Sophie because Sophie lives in France. We've had very little communication with her, only by email. But because of the nature of this case and the impact it could have on the number of guardianships in Bexar County that were created using private process, my firm and I decided it was more important to address this issue with the court than withdraw from the case and allow a default or a reversal to take place. I want to briefly address the issue about guardianship abuse and Ms. Fairley's conduct. I think if you were to look at the order, the New York order, which I presented to the court as an exhibit, I think Juliette Fairley is the poster child for guardianship abuse. If you look at the findings that the New York court made, she made an agreement while she was in Bexar County. She initially filed a guardianship application for her father in Bexar County. It got dismissed or non-suited because she reached an agreement that Sophie would continue to take care of her husband under the power of attorneys. And then she kidnapped her father without notice to the power of attorney, to the wife, to the nursing home, took him to New York and drained his bank accounts, had him, knowing that he was incapacitated because she sought guardianship herself in a sworn pleading. Then she had him sign powers of attorney, drained his bank accounts, changed all of the mailing addresses so that all of his money would go to her in New York, and Sophie had to hire attorneys to go to New York. Now, in New York, Juliet actually filed an application for guardianship herself and had him served in New York. And at the hearing on whether or not a guardianship should be appointed, she refused to bring her father to the court. The court went into recess, ordered Mr. Fairley brought to the court, interviewed him, and then appointed Sophie as a co-guardianship under emergency authorization, and entered findings that Juliet's conduct was improper. And so that's why we're here today. And it's that sort of situation which our probate judges looked at and said, we really do need to be able to be effectively getting process without having to wait for a constable or a sheriff to get through their backlog and to go find people and serve them. Because anybody who uses sheriffs and constables for service know that they do not take the time and effort that a private process server does to track somebody down and to have them served. And the other reason is that it is much better for an incapacitated or possibly incapacitated person, such as Mr. Fairley, who had advanced Alzheimer's disease, to have a gentleman come up and hand him the document, which happened in this case, as opposed to having an officer, a uniformed officer, knock on his door or come into his room in a nursing home. That's very distressing.
But whichever process is better, don't we have to comply with state law if state law requires it to be a sheriff? A judge can't say, well, I really don't think a sheriff is a good idea, so I'm going to do something different than what the law requires.
Okay, so that gets into the question of which statute controls, okay? And if you look at the law on general versus specific, 101.151, which Mr. Enoch cited for personal service, and you have to have the return and all that. That is subchapter B says methods of serving citation or notice, persons to be served. 105.103 is in subchapter C, which governs notice and citation required for application of guardianships. So that's specific as to guardianships. The amicus is
why couldn't it be the case that both are more specific on different things? So, for example, that 103 is more specific as to an application for guardianship and who gets the service, but 051 is more specific on the method and who gives the service, which is the question here. Who is the person that is serving it? It seems to me each could be more specific on part of what you need to do, and the part that we're wondering about is who's supposed to be handing the paper to the person being served.
Right.
And so if 051 is more specific on that, why wouldn't you read 103 and say, it says, well, the sheriff or other officer, what does other officer mean? Well, maybe we should go look at 051, which is more specific on that question of who gives the service, and we see that it says sheriff or constable.
The reason you don't do that is because 101.051 says the constable serves the person. 101.103 says notice and citation for application for guardianship, and A says sheriff, constable, or other officer shall serve the application for guardianship, specific document, and a proposed ward.
I absolutely agree with you. I think that's right, that 103 is more specific on what you're serving, the application, and who receives the document, the ward. But what I'm asking is, why is 051 not more specific on who gives the application?
Because the section 105.103A says sheriff, constable, or other officer shall serve the application for guardianship on the proposed ward.
I think it says sheriff or other officer.
Right.
But why don't we look to 051 to figure out who is an other officer?
Well, 101.051 doesn't define other officer.
Well, it says or constable.
It does say that. But if the legislature intended for constable to be the only thing that is an other officer, they would have put it in the section specifically for serving guardianship papers on a proposed ward, and they didn't. And that gets back to the question about why do we think this is jurisdictional? Because they're relying on all of the case law that relates to default judgments. And this is not a default judgment case. This is a case where Mr. Fairley, it is undisputed that Mr. Fairley needed to have a guardianship. Juliet herself sought guardianship. There is a Court of Appeals opinion in which she appealed one of the orders, and the court said, Ms. Fairley, you had an opportunity to contest your mother being appointed Mr. Fairley's guardian, and you didn't do so, and therefore that is affirmed. So there's no question that he needed a guardianship. And the reason I bring that up is because this court has talked about in the Dubai and the City of DeSoto case, what do you look at to see if something is jurisdictional? And so you do certain analysis to reach that determination. You just don't say, well, as a matter of fact, and you ask this question, why is it just because citation is required? Do you just use that as a fallback? Well, I don't think we do. I think we look at whether or not the jurisdictional approach can be used to strengthen and reduce the delayed attacks on judgments. So you
don't think that proper service is necessary for personal jurisdiction to attach?
I think that in the context of whether or not the administrative orders of the judge and compliance with those orders and getting actual service. A lot of cases, if you don't serve them at all, I get that. That's not this situation. So you begin with a presumption that it is not jurisdictional. Because
so even if and I understand your point about the Bexar County order governs, but if they had not complied with the Bexar County order, say, and the service was not in compliance with that, you would say the court would still have jurisdiction as long as he had actual notice, or what's the test for the court to acquire personal jurisdiction?
So I think that you would, as long as he had, because the guardianship rules have all sorts of provisions in it to protect. So you have an ad litem who's appointed. You have personal appearance. You have involvement of the court. You have no contest by the other side that he needs a guardian. So I do believe that as long as the processes are in place, what you look at is was there a clear legislative intent that this is jurisdictional? And then you look at specific consequences for noncompliance. And
if processes have to be in place in order to acquire jurisdiction, then how can you say it's not jurisdictional? I'm not sure I understand that.
Because when you look at the strict language of the statute governing service, it does not say that it is jurisdictional. There are statutes that say that. And that's what this court did in DeSoto and Dubai, is they looked at, is this actually clearly legislatively intended to be jurisdictional? And there's nothing in any of these statutes that say these are jurisdictional. There is case law. But then if you look at in re guardianship of Jordan, where they complained that there was failure to personally serve the ward, and in the end, they ended up serving the power of attorney because all attempts to serve the ward had failed. And the court said, yes, we're not going to call that jurisdictional because they applied what this court said to do when you look at whether or not something is jurisdictional. And so just because a statute is mandatory doesn't make it jurisdictional. That comes from...
We just said last term, we had a per curiam Spanton versus Bella that had to do with whether the citation said the street was Heather's Hill instead of Heather Hills, and I don't know if you saw that, but it says very clearly trial courts lack jurisdiction over a defendant who was not properly served with process.
And those are default judgment cases, are they?
Well, but that's not what this statement is addressing. The statement is saying trial courts lack jurisdiction over a defendant who is not properly served with process. It seems difficult to understand how we can even question that principle.
Well, I think that the way we get to the result that my position seeks is that the statute does authorize another officer, that the Supreme Court has authorized the following people to serve, that the statute says that the other officer can be a person who is authorized by the court to serve, and the service was provided by somebody who was on the list and gone through the courses. And so when you look, going back to this jurisdictional issue, if you look at the consequences that result from the interpretation that they're asking for, it will be to invalidate thousands of currently pending guardianships in Bexar County. And in light of the fact that this case no longer has a live controversy, I do not see that it is something this court should do. I think the issues are moot.
That's what makes it so puzzling that the probate court dismissed this case.
Well, when, let me talk about the transfer issue, okay? So when the wrongful death claim was filed, as the court is well aware, people who are guardians are required to post a bond. And judges, probate judges, are required to post bonds. And judges, probate judges, can be liable. They have a requirement to annually check on the welfare of the ward and to make sure that everything is done appropriately. And annually, they have a requirement to ensure that the guardianship need not be revoked, set aside, modified. And so we have that protection from both the court and the bond. And the allegations in the wrongful death claim were that Juliet, in her duty as guardian of the person, didn't take good care of him and allowed his medical care to be deficient. Well, that is the exact precise role of the guardian of the person. And it is the exact precise reason that she has a bond. And so that is why when she filed that lawsuit, it was properly transferred to probate court because it had to do with the action she took while she was guardian of the person, fully bonded and under court supervision. And so just because he died, the probate court didn't lose jurisdiction. The statute's got several procedures that have to be followed before a guardianship is closed and before the guardian can be discharged and the bond can be released. And those are allow paying for funeral expenses, file a final accounting, and all of that happened in October. And then Judge Spencer signed the order closing the guardianship. This was after she had dismissed the wrongful death claim under 91A. And then she released Sophie from the bond. That's when the guardianship was closed.
And Mr. Enoch stated that the counsel appointed to represent the interests of the ward could not waive any defect in the service of process by not objecting to it when counsel appeared on behalf of the ward. And what's your response to that?
So the argument that an affidavit of return is insufficient or not appropriate and doesn't meet all of the requirements, again, let's get back to general versus specific. 151 is the general statute that governs service in general. 153 is specific as to proof of service. And it says, subchapter D, return and proof of service or notice. It says, proof of service in each case requiring citation or notice must be filed before a hearing. Proof of service consists of A, return of service if by sheriff or constable. B, or 1, 2, sorry, I feel like car talk. If the service is made by a private person, the person's affidavit. It doesn't say what has to be in the affidavit.
Well, I'm just wondering about the capacity of appointed counsel for the ward. Is the capacity limited such that neither the ward, who's presumably at least alleged to be incompetent to make that decision, nor his appointed counsel can act on his behalf to waive defects in service of process? Do you agree with that position, or or is there something else we should be aware of?
I think it can be waived, and I also think that that is overcome by the fact that Mr. Fairley was in the New York court because Juliet Fairley filed an application for guardianship and had him served in New York. So he had been served in a guardianship proceeding by Ms. Fairley in New York. And so if he gets served again by Bexar County, in the Bexar County case, he's already there under the jurisdiction of the New York court, who had the authority and did, under her emergency powers, appoint Sophie to be the guardian. And so I think that you get around that problem, if it is a problem, because I don't think it is. But I think that the fact that the New York court had jurisdiction over him when he was brought physically to the court, because Juliet is the one who filed and had him served, I think that covers any question about proper service in the affidavit. But I also believe that the return requirement does not follow all of this case law they're talking about with default judgments and return of service. I don't think all of that, dot your I's and cross your T's applies to this situation. This was not a default judgment. He was served. He did appear. He did have an ad litem. He had a judge who supervised everything that Sophie did. He had a judge who got reports on the well-being of the ward. And we're not talking about a situation where we need to stop this guardianship abuse. We're talking about a situation where Mr. Fairley needed to get back to San Antonio. He was living in a bunk bed at Juliet's apartment in New York, and Sophie couldn't find him, was denied contact with him. And the New York court said, you send him back, and you pay attorney's fees, and you put that money back, and the powers of attorney that you had drafted for your father to sign knowing he was incompetent are all withdrawn. They're struck. Sophie's power of attorney is now reinstated. Sophie has power of attorney over the person. She brings him back. So, and in fact, there is one case, as I cited, where the power of attorney was served and that was sufficient. Well, Sophie was the power of attorney. And so I believe that this case is a moot. I don't think there's a live controversy. If the case were to be returned to the court, there's nothing that could be done.
Well, I assume, and we can ask your opposing counsel when he gets back up, but if we found that there is jurisdiction, that the trial court did not have jurisdiction, the remedy would be to say that the transfer order was void. So the wrongful death claims are reinstated in the district court? Why wouldn't that be the remedy?
Well, that would be the remedy, but it would be a remedy with no solution, because the estate, the claim she's making about the trust, Juliet was not a beneficiary of the trust. All of the assets have been distributed pursuant to the terms of the trust. And so go back and get a judgment against Sophie that's uncollectible, that's not, she's not even going to be able to be served. She's in France.
Any other questions? Thank you, Ms. Cabaretta.
Thank you.
Mr. Enoch, you have 5 minutes.
Yes, Your Honor. Mr. Fairley never appeared in any of the proceedings. That should answer that question. The other question about whether a default judgment that is rendered when there is no service in the case is void without jurisdiction, this court back in
I disagree that the judge in New York, when everybody came in, said, well, where is the ward? Can he come? And everybody said, I guess disclosed his whereabouts and recessed and said, go get him and bring him over. That didn't happen.
He never did appear. In fact, part of the argument was that Juliet Fairley was not cooperating with the court that was there. But I will tell the court that in 1984 in Smith versus Commercial Equipment Leasing, you all held that if there's not service in the case, the order entered in that case is void. And the question really was, suppose I never hear about a default judgment. Suppose I never have a writ of error to the Court of Appeals, or I never have a follow-up within 2 years suit. What happens if I don't find out about it until 5 years later, somebody tries to execute? No, the logic is if I've never been served in this case, that anything the court tries to do to assert jurisdiction over me is void. As I said, Mr. Fairley never did appear in court. This court has heard a lot of argument about, Ms. Fairley. This court has not heard, and we don't think it's relevant, our argument about Marciette. The question was, did the probate court have jurisdiction? I think even as my learned counsel is commenting here, you can see the potential for abuse if the court can appoint an ad litem, and the ad litem can walk in and say, I think all the service is fine. I think an interested party who makes the service of citation in New York, not that they're not in the case, but they're just not disinterested because they're part of the law firm litigating in this case, that the ad litem ought not to be able to waive the precise details of the service. And I think strict application of the rule should apply. The guardianship temporary was by a private process server who does not affirmatively show on the record disinterested and does not show affirmatively on the record competent. And regarding the return of service, I cited the court to the statute. It is not just their affidavit. It has to be endorsed or attached to the citation. So it was not good. And then the service in Texas is permanent. It is express.
Following up on that distinction that you're making between two different attempts at service, do you agree that in order for you to prevail, we have to agree that neither was sufficient? Or stated the other way, if either is sufficient under the law, then the other side wins. Do you agree with that?
I do not. I do not. I think once they started the process under the temporary guardianship, which morphed into you have the provision that any notice, not just citation, but any notice has to be served. We think even that notice was not, if you decide the permanent guardianship was simply another notice. We don't think it complies by the sheriff, but we believe from get-go, the probate court had no jurisdiction. And remember, the writ of habeas corpus dragging Mr. Fairley back to Texas so they could have this proceeding was under an improper service of citation.
I just want to clarify on the background. The Court of Appeals opinion says that Respondent filed the 91A motion to dismiss. Petitioner filed the TCPA motion to dismiss that motion. And the probate court denied petitioner's motion, and petitioner took an interlocutory appeal from the denial of the TCPA motion to dismiss, which has led me to think all along there's never been a ruling on the Rule 91A motion to dismiss. Is that an incorrect understanding?
That is correct, Your Honor.
Okay, because I can't figure out why you didn't appeal not only the denial of the TCPA motion, but the granting of the 91A motion on the merits. You're not challenging in any way the merits of dismissing the wrongful death claim. You're only challenging the denial of the motion, of the TCPA motion to dismiss the 91A motion to dismiss.
The court dismissed the entire case, and we
sure?
have objected
Because
throughout.
it says it's an interlocutory appeal. We'll figure that out. I'm just trying. I'm trying to figure out disposition, if we even agreed with you, where that leaves us. So, but we'll dig deeper.
Your Honor, if there is no jurisdiction, no jurisdiction can be raised at any time, and we have raised the jurisdiction question on the case as a whole.
And you agree with what I said earlier, that if you're right that there was never jurisdiction, then we go all the way back to the probate court's transfer order, declare that void, which then leaves your client's claims pending in the district court. That's what you think the right disposition would be. Okay.
Yes, sir.
Any other questions? Thank you, Mr. Enoch. The case is submitted, and the court will take a brief recess.